Everybody, my name is Luiza Manuelian. I am here today with Natela Shenon. Thank you so much for joining us today. We're going to talk about the mistakes business owners and employers oftentimes make, and we're going to discuss from two different perspectives. Natela is going to talk about from a business formation perspective, and I will discuss from the employment law perspective. So with that said, let's jump right in. Natela, please take over.
Hello, everyone. Thanks for joining us. I'm Natela Shenon. I'm a corporate transactional attorney with Grant Shenon Alvarez. I am a former litigator, and my firm still does business litigation today. So I've seen it all from many different angles, and I am excited to discuss some of the very, very brutal mistakes that businesses make that can, business owners, that is, it can very easily be avoided. So the number one mistake, I think, all across the board that I see is not having a proper partnership agreement or not having a partnership agreement at all. So, for the purposes of this discussion today, what I mean by a partnership agreement is any agreement between two or more people that are running a business together. So it could be an operating agreement if they're running the business through an LLC. It could be a shareholders agreement if it's through a corporation. Sometimes people don't know that they should form an entity and they have a joint venture of sorts. They should have an agreement for that as well. So anytime that you're sharing money, effort, or control, you're in a partnership, and you should have an agreement. So why, right? I get people that are so excited, they're starting a new venture, or they've come up with a new idea and they're already seeing the dollar signs, they're going to make so much money, they're going to be best friends forever, they're going to do this thing. So like, why? They trust each other, right? They've spent many, many hours going over how they're going to do this and what they're going to do. Why do they need to have a written agreement? Well, the reason for that is because, oftentimes the initial sort of honeymoon phase, it ends, even in successful businesses, and things either, go wrong, but even if they don't go wrong and they're fantastic, they still become routine. And so when they become routine, people sort of pause and they start thinking, well, am I investing more of my time into this business than my partner? Or, is my partner honoring the promises that my partner made to me with regards to this business when we were starting out? Or the business needs money and I don't have the money to invest into the business, but my partner does, or vice versa. What do we do? Or what if the people just don't want to do it anymore? Maybe they've aged out of the business or someone gets sick. How do you deal with it, right? And so that's when people run into problems, when they don't have a roadmap of how to deal with it at the outset. So a strong partnership agreement covers all of these scenarios that I just described, as well as the roles and responsibilities of the parties, how is performance measured, who does what, who makes the major decisions in the business, who decides if the business should grow or if it should dispose of assets or acquire new assets or branch out into a new line of business. How are those decisions made? What if there's 5 partners and 2 of them want to do it and 2 of them don't want to do it and one is undecided? What happens, right? How's the entity owned? That is also reflected in the partnership agreement. Sometimes people own things if it's just 2 of them 50-50. Sometimes there's 5 people and the ownership is disproportionate. Sometimes people forget and get confused about what they even agree to as far as ownership is concerned. So this agreement also discusses how ownership is held and who puts in how much money at the outset and in the future. And then, how are profits and losses distributed? And then what's the exit strategy? What if one partner doesn't want to be in the business anymore? What if everybody wants to sell the business, but they can't agree on the valuation? What if there are unforeseen circumstances such as death, disability, or divorce? And finally, if everything else fails and they just can't agree, what do they do, right? What do they do short of spending tens of thousands, if not hundreds of thousands of dollars on lawyers and litigating? how do they get it resolved? And so all of these provisions go into a strong partnership agreement, and it's very, very highly recommended that anyone that's in business with not just themselves have this kind of a document, because most lawsuits that we see in our business litigation practice are because of not understanding, not having a roadmap, and people either misunderstanding each other at the outset and thinking that promises were not honored, or sometimes people just forget. So yeah, partnership agreement, always.
Well, with that said, I'm going to jump right into why partnership agreements and agreements in general is extremely important when it comes to employment law matters. Oftentimes I end up dealing with companies, owners who don't have a partnership agreement, and there is a dispute whether they're partners or are they employee-employer relationships. So from the outset, if there is no employment agreement, if there is no partnership agreement, then the question becomes getting the evidence, looking at the factors to determine, was this person acting as an employee versus a co-owner? If the person is an employee, then the facts with regards to labor code violations, the allegations of unpaid wages, overtime, wage statement violations, meal penalties, rest break penalties, all of these things become very critical and very important, because very different laws apply if somebody is an employee as opposed to co-owner. If they are a true co-owner or partner, then they have a partnership dispute issue. If they are an employee, then they're entitled to a host of benefits, and opens the floodgate of litigation of misclassification, wage and hour rights, and everything that I just mentioned with regards to, as well as workers' compensation and FMLA and pregnancy disability leave. Oftentimes, the way I handle these is I have to look at factors, I have to look at evidence to determine whether or not these people were actually co-owners. So if you don't have a proper partnership agreement, then we have to spend money to try to basically prove in court that they were co-owners or they were employees. So if it's considered that this individual is not a co-owner or partner, but rather an employee, the legal consequences can be astronomical. This person, if they are an employee, they can bring a representative lawsuit on behalf of former and current employees for various labor code violations. So what does that mean? So you have one employee, sometimes referred to as the bad apple, that brings a lawsuit not only involving them, but all former and current employees going back 4 years. A class action is a representative suit that resolves claims of a large group of similarly situated individuals. And like I mentioned, it goes back 4 years from the date of the complaint filed. California courts have certified as little as 10 to 30 members for a class action case. So smaller employers are not immune to class action case. In fact, I have many small employers right now that I'm defending them in a class and PAGA suit with as little as 12 employees. Class action suits involve the following types of violations: unpaid wages, right? Includes overtime. If you don't have a correct overtime rate, even regular rate of pay, for example, if you don't include commissions in their pay, bonuses in their regular pay, meal break violations, rest break violations, expense reimbursement. This is oftentimes overlooked. Cell phones, if they're using for purposes of work, gas, if they're using car for work, oftentimes lead to class action suits. Wage statement violations. This is probably one of the easiest one for employees to win. Every time you don't have a proper rate of pay, you miss a meal penalty, guess what? You've got a wage statement violation. Improper calculation of paid sick leave. Again, if they are an employee and not a co-owner, they would be entitled to all of these benefits. Misclassification can also lead to a PAGA lawsuit. PAGA lawsuit is an acronym for Private Attorney General Act. PAGA was enacted in 2004 to help the Labor and Workforce Department agency we call them LWDA, to enforce California's labor laws. It allows employees to sue for any labor code violation on behalf of the state. PAGA lawsuits have caused employers in California, hope you're sitting down for this one, billions of dollars since its enactment in 2004. PAGA lawsuits go back 1 year, which means as an employer, if you're not compliant with California federal or local labor laws, you can potentially be sued every year for a PAGA suit. On average, there are 75 PAGA letters filed with the LWDA every day. This means there are 75 employers in California that get notified of a PAGA filing on a daily basis. Even though a reform was passed last year to limit the filings, it has had the opposite effect, increasing the number of filings. What makes it so enticing for employees' attorneys is because it has a statutory attorney's fees provision. So if they file a suit and they claim 18 different things and they're successful under one theory, they are entitled to their entire attorney's fees. And that's going to be in the hundreds of thousands of dollars. The only defense to a PAGA claim is compliance. It is very, very important to have a proper partnership agreement because you can see if they are going to argue that they're employees, then they have a potential to become a PAGA and class representative, as well as their own individual claim.
The second big mistake that actually is very easily avoided that we see business owners make is commingling business and personal funds, finances, bank accounts, and so on and so forth. So before explaining what commingling actually means, I just wanted to take a step back and explain that people often think that they're going to open up an LLC or a corporation to run their business, and that's going to just give them limited liability protection, right? What's limited liability protection? It just means that if something goes wrong in your business and you get sued and there's a big judgment, the creditors of that judgment can never go after your personal assets. Everything is confined within the business, right? So people often think, okay, that's it, I'm good. I opened up an LLC or I opened up a corporation and I don't need to worry about anyone coming after my personal residence. And that is actually not quite the case. In order to be fully compliant, in order to have full protection, you have to be fully compliant. And part of being fully compliant is also treating the corporation or the LLC or the business entity as a completely separate, both legal and business entity, right? So that means that that entity needs to have its own bank account, not you get checks to the business and then you deposit them in your own bank account, not, you use the company credit card to pay for shoes or for your kids' tuition or for your mortgage. It has to be completely separate from your own. And the business funds have to only pay for those things that are related to the business. And if you, next slide, please. Right, so if you don't do that, why is it such a big problem? Like, what's the big deal? It all goes ultimately into the same pocket. Maybe you have, an S corporation and that it's a pass-through entity and, ultimately, whatever money that the business makes that it doesn't end up spending on its expenses, it still lands in your pocket. So why should you care? Right, and so the reason why you should care is because commingling funds in the examples that I just gave, it actually destroys your liability shield. So if you get sued for something and you end up with a judgment and the creditor of the judgment tries to go after you, you are going to say, well, no, you can't go after me because I had an LLC or I had a corporation. But if they can prove that you actually commingled funds during your operation of this entity, then they'll be able to pierce the corporate veil and they'll be able to come after your personal assets, because the courts will consider you to be the alter ego of the entity and not the entity as its own separate being.
Okay, speaking of commingling funds, from the employment law perspective, Oftentimes in class action and PAGA lawsuits that involve wage and hour violations, because in California, those violations are, the employers are personally liable, oftentimes we refer to the tax records and we look at the profit and loss statements of these companies in order to argue inability to pay or financial hardships. So let me step back a little and explain. Under California law, not paying your employees their full wages is considered a crime. It's called a wage theft. The employer is personally liable for their employees' unpaid wages, which include meal penalties, wage statement violations, etc. Directors, officers, shareholders of the company are personally liable for wage and hour claims. There is no need to pierce the corporate veil because there is personal liability. What ends up happening in reality is when we're defending class and PAGA lawsuits, because the judge ultimately has to approve any settlement we get, oftentimes the violations become extremely expensive, right? Sometimes it's over $1 million. And so in order for us to negotiate a lower settlement amount, oftentimes we resort to the tax filings, right? We say, look, our client doesn't have unlimited resources to be able to pay these exorbitant verdicts or settlements. And so we refer to the tax records, and at times we have to go to the judge under seal to provide financial records to argue why the judge should allow a lower settlement in light of the financial restrictions. However, at times, and we've experienced this at our office, is when we have commingling of funds and the tax records look very suspicious, meaning it might create a criminal or civil liability to the client, we cannot use these records, right? We cannot go to court and say, look, Your Honor, they really can't, because then the judge is going to say, wait a minute, there's a definitely improper commingling of funds happening. So from the perspective of using tax records for class and PAGA cases to settle, oftentimes commingling can have very dire consequences for the client.
So assuming that you've got a partnership agreement and you are not commingling funds, you're in pretty good shape. But contracts with your clients and with your contractors or vendors are just as important as a partnership agreement, because you might have a strong partnership agreement, but if you've got a big conflict with a client or a vendor, that could actually, in theory, completely destroy your business, right? So why, again, right? The reason to have these contracts is because, again, for clarity, to understand exactly what each side is responsible for, when and how money changes hands, and what happens if something goes wrong, right? Without clear contracts, everyone's relying on their memory, and sometimes memory can be selective, and it becomes very difficult because assumptions and oral agreements are hard to prove in court. So specifically, two things in a business, right? A business might be doing a lot of different things, right? But there's generally these two categories for which it's very much advisable to have a contract. So the first category is very obvious, right? If you're a service provider, then you need to have a contract with your client, right? What's the service that you're providing? How much are they paying you? What kind of a service? For how long? When do they pay you? What does it all look like, right? On the other side of the spectrum are the contractor agreements, right? If you're a business, then you are using someone to support your business. Maybe if you're selling a product, someone's manufacturing it for you. Maybe if you're a professional services provider, you are engaging other people to help you do the work. So these contractor agreements, they protect the quality standards, they dictate the deadlines, and they explain who ultimately ends up owning the work product. So what should a strong contract cover, right? Scope of work, exactly what's included and what isn't, both for services and for products, right? So if it's services, then here you're talking about quality, quantity, batches, and so on and so forth. If you're talking about a service, what kind of a service, what's the scope, What does it cover, over what period of time, and so on and so forth. It should also cover payment terms. What's the amount for the entire project? When do you get paid? Do you get paid everything up front? Is it on certain terms? Is it at the end? Is it when on completion? What does that look like? What triggers the payment? Also, sometimes in the middle of working with someone or filling someone's order, circumstances change. Maybe the client now wants something different. Maybe you want something different. And so how do you deal with those situations? So a good contract will usually have a procedure for these change orders, so to speak. Termination. When can either party walk away from this contract? Can they walk away? Sometimes you can. Sometimes you have to, fulfill the entire contract, but you have to pay for the entire contract, even if you no longer want the service. It really depends. That's why it's so important to have these terms very clearly spelled out. Confidentiality and non-disclosure protects proprietary information and trade secrets. For example, we have some clients that are they sell syrups and sauces, right? But they have to give their proprietary recipes to a manufacturer to manufacture those for them, and then they go on to sell them. Well, all those recipes are proprietary to them, so they want to make sure that they have proper provisions in the agreement with their manufacturer that protects the confidentiality and the trade secret nature of these recipes so that no one can essentially run away with them. Then there are intellectual property issues. For example, let's say that you hire a photographer to do a photo shoot. Who owns the photos, right? If there's no contract by law, the photos will belong to the creator, which is the photographer. But obviously, if you're commissioning someone to take the photos for you, you're going to want to have ownership of them. And so we put certain provisions such as work for hire in these contracts. And this is just one example. There are many other circumstances under which you would want these provisions in your agreement. You want to have indemnification provisions, i.e., what if something goes wrong in the middle of this contract being fulfilled by either side, and either side gets sued by a third party about something that relates to this contract? Who pays? Who pays for attorney's fees? Who pays for damages if there are ultimately damages? So a contract will allocate these responsibilities so that everyone is on notice before they get into the contract, before they start the work, as to who's responsible for what. And of course, what happens if there is a dispute? Does it get resolved in litigation, which is very lengthy? Does it get resolved in arbitration, which is more costly? Do the parties have to go to mediation ahead of time, which is always, always, always recommended? So a good contract will have all of these things. The other thing to consider that is very critical is that each contract has to be industry specific. I know sometimes people pull stuff from the internet and they think, oh, I'm providing a service, I need a service contract. Or I'm selling a product, I need a sales contract. But in reality, each specific industry has its own minutia that is mission critical to these contracts. And so it's highly recommended that you actually consult with a qualified attorney who can help you tailor the provisions according to the industry that you are in.
All right, now we're going to jump into contractor agreements versus, independent contractor versus employees. So these are critical, important agreements. There are two different types of agreements. One has to do whether or not a person is a true independent contractor versus an employment agreement, right? For someone that's an employee. So one of the most expensive litigation mistakes involve employers misclassifying individuals as independent contractor versus an employee. I just want to kind of globally point out to, yes, a lot of times I get phone calls from employers saying, but that's what they wanted, Luiza. Why? They wanted to be independent contractors. They didn't want to pay the taxes. It's beneficial to them. That's great. When it turns into a lawsuit, they're going to forget all about that. And the courts look at it as in these people essentially don't know what's right for them, what's best for them. And therefore they take the position that, look, in order for someone to be a true independent contractor, really two tests apply in California. One is the ABC test. It is the strict test, and it is the most commonly used test to determine whether someone is an employee or an independent contractor. I'll go over the details of that in the next slide. But the second one is the Borrello test. The Borrello test is a little bit more flexible, so it is somewhat more beneficial for employers to use. However, it is a little bit more occupation industry specific, and it has the business to business exception. So for the most part, ABC test is what courts often use to determine whether someone is an employee or not. The ABC test takes the presumption that all workers are employees unless the employer meets all three following requirements. One, the worker is free from the control and direction of hiring entity. Work performed is outside the usual course of the hiring entity's business. And three, worker is customarily engaged in an independently established trade, occupations, or business of the same nature as that involved in the work performed. And the burden is on the company to establish all of these elements. So let me break it down. What is ultimately? The first one is the worker is free from the control and direction of hiring entity. You as a business owner, are you telling these individuals what to do, when to show up to work, what to wear, how to communicate with their contacts or clients? How much control do you actually have over this individual? Second is work performance is outside the usual course of the hiring entity's business. For example, this is a law firm. If I'm hiring a plumber to fix the plumbing, then ultimately the plumber is a completely different line of work than a law firm is, right? So therefore, it's two separate types of businesses. Number three, worker is customarily engaged in an independently established trade, occupations, or business of the same nature. Is this person, whatever services they're providing, let's say they're marketing, right? Is this person that's marketing for your company, are they providing a similar type of work to other clients? So these are the requirements, and it's very strict. And as an employer, you have to establish all of them to be able to successfully argue that it's an independent contractor. If it is determined that the individual was misclassified, then that individual can bring a claim against the employer for various violations of misclassifications, including unpaid wages, right? Oh, I worked all these hours, I was never paid proper overtime. Paid sick leave. In California, employers have to pay their employees at least 5 days of paid sick leave. If you're in LA, it's 6 days. So these are all the benefits that an employee gets, but not an independent contractor. Meal and rest break violations, right? These are often every single class action lawsuit almost always includes meal and rest break violations. They're entitled to 10-minute rest break for every 4 hours or a major fraction thereof, as well as a 30-minute uninterrupted lunch break within the 5th hour of starting their shift. As well as wage statement violations. And once again, just like with the class and PAGA wage cases I mentioned, there are statutory attorney's fees provisions. So if they are successful to argue, yes, they were misclassified, then all of their attorney's fees get paid. So the other benefits they would be entitled to as an employee also include the protected leave under FMLA, the California version, CFRA, pregnancy, disability leave, as well as workers' compensation. The consequence of misclassification: if the employer has a true independent contractor, there needs to be a clear agreement identifying the role of the contractor, the anticipated project, as well as compensation and expectations. If the individual is an employee, then an employment agreement needs to outline the expected role of that employee, compensation, and all available benefits, including overtime, meal and rest breaks, paid sick leave, job protected leave, such as FMLA, CFRA, pregnancy, as well as workers' compensation. The agreement needs to identify all of these things. If it is unclear whether the person is an employee or an independent contractor, the California Supreme Court has indicated that it will be considered as an employee. This is why it's critical to have a proper designation and agreement from the outset. The consequence of misclassifying an employee can trigger both an individual suit and a class action and PAGA suit. Both the individual and class action can go back to 4 years of unpaid wages, meal and rest breaks, plus statutory attorney's fees. So once again, instead of defending these suits, the better approach is to be proactive and properly classify this individual.
Another thing that we unfortunately see business owners do, or actually don't see them do, is get proper insurance. It's interesting because insurance is obviously the kind of thing that you don't really need it until you need it. And a lot of business owners, sometimes they don't even know what's available to them. That's why we thought that it was important to bring it up today, and what protects them against what. And B, they just think like, oh, I'll get insurance when I make a lot of money, without realizing that regardless of how much money their business is making, something could go wrong and they really could benefit from having proper insurance, because sometimes you do everything right and it's just sort of a happenstance or a natural occurrence that you cannot anticipate, or somebody gets hurt, and that potentially could destroy everything that you have worked for. So what does having proper insurance, what does that do for you? Generally speaking. So it provides a legal defense. So if you get sued for something that is covered by your insurance and you are properly insured, your insurance carrier will pay for your lawyer. And legal fees can get very, very, very expensive. So this is a huge thing. I've seen legal fees, not mine, but others. I've seen legal fees bankrupt businesses. So it's important to have insurance so that does not happen to yours. It will also cover any settlements or judgments if you do get sued and you happen to be in the wrong and you have to pay up. It will potentially protect your business continuity. Basically, let's say there's a flood and it floods your warehouse and you're not making any money, you cannot sell the inventory that you have, and you were hoping that the inventory you have would sell and that would give you more money to buy more inventory, and now it's gone, right? And you cannot pay your employees, so you have to let everybody go and start from scratch. So if you have proper insurance that has business interruption protection, the insurance will pay your payroll and they will pay for your rent and whatever else that is covered that will be reasonably found to be required for you to run your business as usual until you can recover and get back on your feet. And the other thing too is it just shows your clients and investors and regulators that you're responsible. Oftentimes, under a variety of different circumstances, a lot of it obviously is in like construction and maybe like manual labor projects, because people could get hurt. A client won't even sign a contract with a contractor without proper proof of insurance. So let's talk about the most relevant insurances that are out there. So the first one is general liability insurance, and that covers any kind of accidents, property damage, bodily injury claims. Let's say a client comes into your office and they slip and fall. Well, your general liability insurance would cover something like that. Same thing if, let's say, there's a fire and all of your computer equipment burns down. General liability insurance would cover something like that, your personal property. Then there's professional liability insurance, often referred to as errors and omissions, and that covers mistakes in your professional services or advice, right? So for example, if a lawyer gives you poor advice and you act on that advice and it screws up your case, well, guess what? You can go after their professional liability insurance for giving you bad advice, and as the lawyer, it protects them against having to pay you out of pocket because their carrier is going to pick it up. Then there's workers' compensation insurance, and that is actually required in most states, especially in California. And that just covers any injuries that any of your employees might sustain on the job. It could be a back strain or a slip and fall, really any injury that is incurred in the scope of work, basically, on or off your premises. Then there's commercial property insurance, and that protects your office equipment and inventory from fire, theft, or damage. A lot of people who had this insurance during the most recent fires are probably very happy that they had it. So, you know, like I said, it's the kind of thing that you don't know you need until you need it. And a lot of the times people think, that's never going to happen to me. And then it happens. Then there's cyber liability insurance, and that covers data breaches, ransomware, digital threats, and it's pretty critical in almost every industry nowadays, especially if you retain and maintain any kind of client data, personal and or financial. And then there's directors and officers insurance that protects leadership against claims of mismanagement or any kind of fiduciary duty breaches or board level disputes. And oftentimes in bigger companies, directors and or officers won't accept their position without proof that the company has this kind of insurance. So it's a big world of protection that exists out there, and it really could be useful under many different circumstances. It's really worth the cost for sure.
So before I jump into the employment insurance, what we call EPLI, I do want to point out an example of what Natela just mentioned about workers' compensation. Oftentimes, things that you don't think is workers' comp is actually workers' comp. For example, recently I had a case where a client called and said the employee is saying that they're stressed from work. They have anxiety and depression from work. So I told them, well, guess what? Give them the form, have them submit a claim to their workers' comp provider. Because technically, if it's stress or anxiety that is the result of work, then it's technically should be through workers' comp. All right, with that, I'll just jump to the employment practice liability insurance, what we often refer to as EPLI insurance. This is specifically an insurance for claims filed by current, former, and prospective employees against employers for illegal acts such as discrimination, harassment, retaliation, wrongful termination. And I want to point out that it specifically states prospective employees, meaning if there is a claim of discrimination by an applicant where they're claiming that there is discrimination based on sex or gender, etc., even those individuals can file a lawsuit, even though they're not quite technically your employee. EPLI helps cover legal expenses, including attorney's fees, settlements, and damages related to employment practice lawsuits. Wage and hour lawsuits, which are those involving claims for unpaid wages, the ones that we mentioned earlier, which is overtime, regular rate of pay, bonus, commissions, as well as meal and rest breaks, paid sick leave, etc., including class action and PAGA lawsuits that involve wage and hour claims, are usually not covered under the typical EPLI policy unless the employer requests costs of defense coverage. So this is something you have to specifically request. It is imperative to understand that even if you have an EPLI policy that includes wage and hour component to the policy, it does not cover the actual settlement judgment of the wage and hour case, and it does not cover the attorney's fees for opposing side. It only covers the cost of defense, meaning the litigation cost of defending wage and hour suit, including class action and PAGA suits. It often has a very high deductible, such as $100,000 retention policy. This means the employer does not get the benefit of the insurance until it spends $100,000 out of pocket first in defending the suit. Even then, the employer still has to pay the settlement amount verdict out of pocket. The policy also limits how much in attorney's fees it would cover. There's a maximum coverage allowed under the policy. So EPLI policy is recommended for essentially most allegations regarding retaliation, harassment, including sexual harassment claims, etc. However, there is a clear exemption with regards to settlements and verdicts resulting from wage and hour claims. Compliance with California federal local labor laws really is the employer's only defense in these types of claims. Real life examples of class action and PAGA settlements, just to kind of give you an idea, ultimately, when employers don't comply with labor laws, what it comes as to the cost out of pocket, right, to them. Class action PAGA claims are the most expensive claims for employers to defend and settle. Oftentimes, the first phone call I get is, how do I stay business? What do I do, Luiza? And thankfully, so far, none of our clients had to go bankrupt or go through their personal assets to defend these suits. But that's a serious conversation that we have on a normal basis. Class and PAGA claims are valued based on number of violations and the work weeks the employees worked within the class period. So when we get the case, we look at the complaint date and we go back 4 years from that. So now we're going to look at records going back 4 years from the complaint as to the number of employees, number of violations, number of work weeks. On average, depending on the size of the class members and work weeks, these cases settle anywhere from $300,000 to multi-million dollars, not including defense fees. Most cases settle through mediation as it is the least expensive method for employers. Defending in court through class certification and trial can run easily over $1 million. Most insurance companies, even if you have a PLI that covers wage and hour defense costs, do not want to litigate these cases due to the litigation costs, because it's going to require more than $100,000 to try a class and PAGA case.
And lastly, one, again, of the most important things that a business owner can do for their business is to keep clean corporate books. There are several reasons for that. A lot of people think that, oh, I need to keep clean financial records in case I ever get audited by the IRS. And yes, that is true. That's probably a good practice. But it's not just about the financial records. It's also about your corporate records, your stock ledgers, your minutes, your resolutions, and so on and so forth. So first of all, the same way as we talked about commingling funds, another way that someone can pierce the corporate veil and reach your personal assets, even though you have an entity, is through alleging that you are not complying with corporate formalities. And one of the ways to not comply with corporate formalities is to not keep any books and records, corporate books and records, minutes, resolutions, and so on and so forth. So basically, by not keeping those, you are once again exposing yourself to all kinds of alter ego theories and to your entity not giving you the protection that you signed up for, number one. And number two is, eventually people want to sell their businesses. You want to sell your company. So guess what? When you're selling your company, the buyer is going to come and they're going to do due diligence on your company. And as part of the due diligence, they're going to want your books and records. And it would be good if you had something to show them. Sometimes we end up going back like 20, 30 years and we end up having to recreate everything from the very beginning. And half the time people don't remember what happened back then, and it becomes very challenging. So just to explain what clean books mean, it's accurate, up-to-date financial statements, obviously, and most people are going to do that because they're afraid of the IRS, but it's also documented ownership of stock or membership interest units. Sometimes people forget, or they fight about what they own, and then they can't show the court anything to account for it. They just say, oh, we had an oral agreement. I was going to have 30%, he was going to have 70%, but you know, the other partner is saying, no, that's not true. It was going to be 50-50. And if you don't have proper records, then, you know, that turns into a disagreement. And also it becomes difficult if you are eventually looking to sell the business. It becomes difficult to show a chain of title, just the same way on the house, you want to have a clean chain of title. You also want to have a clean chain of ownership in these entities. And sometimes what happens is there are entities that have been around for 30, 40, 50 years, and they've gone through many different owners. People would buy in, they would sell off, and then it gets really messy, and then you don't know what you're left with and who sold what to whom. So it's important to keep that very clean and very organized. Also, any kind of signed contracts that you have with your customers, with your vendors, you want to make sure that they're actually signed. Because sometimes people will have contracts and they'll feel really good about putting them together, but somehow they don't go the extra mile and they don't get them signed. So unsigned contracts, they don't mean anything. You might as well just have a verbal agreement. Board approvals for any major transactions, proper minutes if you're a corporation, whatever is statutorily required in your state. And then also obviously like proper tax filings and business licenses in whatever jurisdiction that you are doing, you're doing business in. And so just to sort of close the loop on when you're selling your business, why it matters to have proper record keeping, I think that it also shows the potential buyer that you are organized, right? And so if you're organized in your records and in your papers, there will be an assumption that you are also organized in the way that you've been running your business, which is likely going to, I don't know if it'll increase your valuation, but it certainly won't decrease your valuation. Whereas if a buyer comes in and the seller's business is a mess and it's not clear what the records show, then there might be some apprehension or skepticism as to how accurate the numbers are, how accurate the contracts are, and that could actually heavily discount the valuation that you would get for your business. And then also, why go through the trouble of having lawyers and accountants clean up your mess and spend money on it when you just do it along the way, and it's not very difficult, and it just makes your life a lot easier in the future, and it doesn't delay the closing of the transactions if you are selling your business. Otherwise, if it's a mess, it takes a really long time to parse through it and figure out what's what. So, a company with strong and good record keeping has a much better chance of being sold quicker and for a higher price.
Okay, so I think from the employment law standpoint, the record keeping is non-negotiator, right? You have to have good record keeping. It's absolutely critical, both in the sense of when you're dealing with wage and hour issues that I just talked about from class action and PAGA perspective, as well as discrimination, harassment, and wrongful termination, those types of claims. So payroll and human resources record keeping. In California, employers are required to keep their employees' payroll and time cards going back 4 years at the very least. I personally advise my clients to keep time and pay records for at least 5 years in case we're dealing with wage and hour lawsuit, right? As I mentioned to you earlier, we go back from the date of the complaint to 4 years. So as the case proceeds, it's likely going to go 5 years or more. So I recommend 5 years at the very least. Second, employers are to provide their employees with their time and pay records within 21 days of their employee requesting them, or there is a civil penalty of $750. What does that mean? If you have employees who say, I would like to see my payroll records and my time cards, right? They're entitled to it. You have 21 days. What if an employee leaves your establishment? Well, they can get a lawyer or they can request it themselves. You have to provide those records. Relying on payroll company to maintain your time and pay records is not an excuse. Oftentimes, payroll companies delete records without properly notifying the employer. This has happened to my colleague Evelyn and I. We do a lot of class action and PAGA cases, and oftentimes, twice this has happened, we're in the middle of class action case and our client reached out to us and says, hey, my payroll company told me that because I changed a different package, they deleted all of my time and pay records. Well, guess what? Now we're defending a massive lawsuit without proper records. So it is very important for you to communicate clearly with your payroll company to maintain accurate records. Personnel records. Employers are required to keep accurate personnel records for each employee. And What are personnel records? What are you supposed to keep? I'll go through the general list. It is their I-9 form. And by the way, I-9 forms are more important now than ever, thanks to the crazy ICE raids that employers are now facing. My recommendation, as a side note, if you're an employer and you have employees, you probably have I-9 forms in their personnel file. I recommend you make a copy of their I-9 forms, create a separate binder of only their I-9 forms. So just in case you have a warrant or a subpoena from the federal government for their employment or their status of citizenship, you just provide the I-9 form and not their private information in the personnel file. All right, so the I-9 form, the employment agreements, if you have any employment agreements for your employees, any reprimands, any performance improvement plans, or any write-ups or complaints. I can't emphasize the word complaints. Any complaints the employees brought against others or complaints brought against them. You need to have copies of these in their personnel file. Investigation reports regarding allegations of a complaint. I've defended multiple harassment lawsuits where there is zero investigation report. What is it? What's a report of investigation? Somebody's making a complaint. You need to investigate it. You need to have clear documentation and a result that, based on preponderance of evidence, what was your result of the investigation, and communicate that to the complaining employee. All of that needs to be in the personnel file. And the termination letter. Oftentimes they terminate without saying why, and then it turns into a wrongful termination claim. And so we have to fight over, do depositions and discovery. What's the true nature of the termination? We have no documentation. Another very important one, which often turns into litigation, is was the employee provided a proper amount of FMLA or sick leave, right? You need to document when they go on leave, especially when it's an intermittent leave. Intermittent leave means they can take 2 weeks off now, come back to work, take another day off. They get up to 12 weeks of leave under FMLA and SIFRA. But oftentimes employers don't keep good records of those days are considered on SIFRA leave or FMLA leave. And you have to have a job protection when they go on these leaves. So you have to communicate that in writing. Hey, employee, you are entitled to your job when you complete your FMLA leave. All of this has to be documented. It needs to be in their personnel file. Pregnancy disability leave, another one that requires a good documentation regarding the leave, when the employee intends to return to work, and any documentation from their medical provider regarding their ability to return to work. One of the most common types of allegations, especially there are some plaintiffs' firms that we deal with all the time, and it has to do with work accommodations and restrictions from employees' medical provider. Whether it's a workers' compensation doctor putting work restrictions or a private doctor advising the limitations during the employee's employment, all communications regarding work restrictions and accommodations need to be properly documented. There have been many lawsuits regarding failure to conduct interactive process and failure to accommodate medical restrictions without proper documentation, these becoming extremely to defend. So what does that mean? Well, your employee says, I hurt myself, whether it's through car accident or something to do with work. They need to provide a doctor's note that says, for example, I can't lift anything more than 5 pounds, or I can't bend down to my knees. Well, if that's the case, then that needs to be documented, and you have to respond to that restriction. And I recommend that to be in writing. Can you accommodate it or can't you accommodate? If you can't accommodate, why can't you? Is it unduly burdensome? All of that needs to be documented. Employers are also to produce the personnel records within 30 days of request by their employees. That's also a $750 penalty if you don't. Last but certainly not least, the infamous employee handbook. The very first document I ask when I get a phone call, whether it's a class action case, it's an individual harassment case, I say, where's your employee handbook? Because that's the Bible of the company, right? That's where you put all of your policies. What are you expecting from your employees? these are your rights, your meal breaks, your rest breaks. This is what you're entitled to when you go on an FMLA leave. All of these things, but also really importantly is if there is a complaint, where do they go to, right? If a supervisor is harassing them, your employee handbook should say, hey, here's our HR person, call them. So that if I'm defending you in a lawsuit, one of the first things they say, hey, in your handbook, or one, you don't have a handbook, or two, if you have a handbook, you don't say who can we complain to if there is harassment. So your first line of defense in all of this is your handbook that identifies very clear policies. When you process payroll, you have to put them on notice, right? Is it semi-monthly? Is it bi-weekly? Is it weekly? All of these things need to be documented. All right, we have few minutes to ask some questions. I think we have some already actually posted in the chat. Let me see if I can pull them up. Okay, I think the first one is, what is the process for transitioning a 1099 contractor to an employee if misclassification occurs? Well, I think we need to evaluate to see what are the potential violations and come to an agreement, perhaps a written agreement where we pay a certain amount depending on the violations with the individual employee, and they agree to release those claims, and then you hire them as an employee. So that would be my recommendation. The next one is, are we talking about workman's comp insurance? I think that may have been answered because Natela was talking about different types of insurances. So yeah, each insurance covers a different area. And so that would, the answer depends on what the allegation is and which insurance would apply. Is there any chance you could please touch on the piercing the corporate veil side?
Yeah,
Before-
we can go back to it and I can speak to it one more time.
Yeah,
Wanna go back
okay, you want to address that? Should I pull up the slide?
Yeah, let's. pull it.
Okay. There we go.
So what does it mean to pierce the corporate veil? My apologies. Okay, my phone was ringing, but it's about to stop. I can't mute myself because I'm speaking, so hopefully this is not distracting to anyone. So I'm just gonna give you a brief overview, I guess, once again. So again, having an LLC or a corporation gives you limited liability protection. That means people can't go after your personal assets, right? Unless whoever is suing your company can pierce the corporate veil and get to you personally. Under what circumstances does the corporate veil get pierced? It gets pierced if there's a commingling of funds, like we discussed, right? If you're treating your business as your personal piggy bank, and or if you are not complying with the corporate formalities, i.e. keeping proper books and records. So all of this is to say, like, big picture is that the law just wants you to treat your entity as an entity, as a separate being. What makes it an entity, what makes it a separate being? Having its own bank account, using its own money for, for its expenses and not paying for your personal expenses. And also having these corporate records in place to formalize who the owners are, what the entity is doing, and so on and so forth. So as long as you are complying with these two things, you should be okay. I hope that answers the question.
So I'm sure there will be more probably. Oh, it looks like we have one more, I think. Will the presentation be distributed? Yeah, we don't have I don't think, Natela, do you have a problem sharing the
No
slides?
problem at all.
Yeah, I think we have it recorded too, so if you guys want, we can send you the recording as well as the slides. I did want to just quickly point out, so if I could give advice, besides everything, we talked about today, I would say the most important thing is, as from an employment standpoint, is really auditing your time and pay records. If I could part anything as a preventative measure, would be audit your time and pay records to make sure you're in compliance. So let me see, I think we have, all right, here we go. Oh, thank you, very informative.
We're good. Thank you guys so much for joining us. Hopefully
Yeah.
this was useful, and reach out with any other questions.
Yes, please reach out to Natela if you have any questions regarding business transactional or business litigation, and reach out to me if you have any employment matters questions. All right, thank you, everybody.
Thank you.
Bye.
Bye.